determined that Mr. David's negligence was a, quote, legal cause of damage to Gary Massey, and that the breach of fiduciary duty of Mr. David resulted in damages to Gary Massey, unquote. That's what was presented to the jury, and that's what the jury decided. Now, the instructions given to the jury were exactly as embodied in this verdict. And those instructions were proposed by Mr. David. They were not the instructions proposed by Mr. Massey. They were David's instructions. And David's written case management statement, this statement of the case was made, quote, whether David's breach of fiduciary duty or negligence was the legal cause of damages to Massey, unquote. This is the phase one trial we're talking about. And in that same document, David's position is quoted as, quote, Massey's claim in the prior litigation was settled at or for substantially more than its value, and he has suffered no legally cognizable damage, unquote. So
wasn't there some discussion about how to proceed in the phase two trial that you participated in?
I participated in everything, yes, Your Honor.
And wasn't it generally agreed that you had to do the trial within the trial?
Never agreed by us.
What was your proposal as to how you would assess damages?
The proposal as to how we would assess damages, had we ever gotten there, Your Honor, would have been that the jury be told that the phase one jury had determined liability, and that its job was to assess damages. The phase one jury had determined that their damages were somewhat greater than $795,000, and the phase two jury must return an award of $1 or more, whatever it would decide. That's what we would have proposed had we ever gotten there. But
the $1 or more part, how would that phase two trial take place in a way that would permit the jury to make that determination?
The phase two jury should not be deciding liability. All it would be deciding
is damages. How do they do that?
How do they do that?
Right.
Well, first of all, they say we've got to find $1 or more, Your Honor.
All right. So
it'd be nominal damages. If in fact the phase two jury, in its own mind, were to decide that the phase one jury somehow made a mistake.
All right. So if you're correct on this point, do you get any more relief than that we send it back and say, give him $1?
I don't think, Your Honor, you'd be authorized to do that. I think you'd be authorized to send it back to say he must receive $1 or more, as determined by what a phase two jury would decide as to the actual damages. In other words, if the phase two jury were to decide that the actual damages were $1 million, then the award would be $205,000. If it were to decide it was less than $795 or less, it'd be $1. That's the position of the plaintiff in this case. And the question is, what did the phase one jury decide?
But how was the jury supposed to decide as between $795,000 and $1 million?
Your Honor, we're going to submit evidence as to the actual injuries that Mr. Massey suffered, if I understand your question. There's plenty of evidence as to his actual injuries, both in terms of his physical injuries and to his economic injuries, that we would submit to the jury.
So in your view, the only thing that was proper in the phase two trial, or would have been proper, was looking at how seriously ill he had become.
And what he had lost as a result of it. That's correct. Damages. That's what is ordinarily determined in a phase two trial, is to quantify the damage. The phase one trial, the jury decided that he suffered damages. Now, in this document that I've indicated to you, David insisted all along that damages were to be measured in phase one
But aren't you mixing up two things? I mean, isn't the measure of damages what the legal malpractice cost? Not. I mean, in one sense, isn't that what you have to prove, that if the settlement had not been accepted, if the trial had occurred, a recovery would have been had.
We proved that. That's what we proved in phase one. That's what the phase one jury decided, Your Honor. That's exactly.
But then when it comes to
the
damage,
instruction here was not, was there negligence, period. Was there breach of fiduciary duty, period. But was there negligence that caused legal damages? And in fact, you see, we presented to the jury all of the evidence of causation, of both of the injury and of causation of David's wrong. We presented to the jury what the settlements were. We presented to the jury the evidence that would have come in as to the damages that Mr. Massey suffered, including especially the $6.5 million damage assessment. And I argued to the jury, I said to the jury, look, what would the phase one jury have decided? And let's assume that it had just decided the damages were $3 million. What would Mr. Massey have recovered? $1,700,000. That was the argument I presented to the jury, and the jury decided.
what was the point of bifurcation?
The point of bifurcation was to set the second trial to determine the amount, to quantify the amount of damage.
But you're telling us you already did that in the first trial.
The jury was not asked to make that determination.
Well, the first trial, it seemed like, that established negligence and the causal factor. And the issue for damages was a fight for phase two. That was a bifurcated issue. And the damages could be zero. Otherwise, why are you having a bifurcated trial?
We had a bifurcated trial, Your Honor, because that's the way the court took it, or set the matter. And the notion, from our point of view, is that Mr. Davis would not have to come in with all of his evidence as to refute our damage evidence, if he didn't want to, you see. But the point that I'm trying to make is what was actually decided here, what was actually tried. This court and the court below cannot ignore a jury verdict as to a finding of liability, and that's what the finding was.
Well, Mr. Little, in your first trial, did you put forward evidence of the responsibility of Coopers and Cabot for injury to your client?
Yes, sir. We certainly did. We put forward all of the evidence, you know, as I point out in the brief. Evidence of Mr. David's malpractice, evidence of the omissions of Coopers and Cabot, evidence of the negligence of Coopers and Cabot, evidence of causation to Mr. Massey, and evidence as to the damages that he suffered. We put forward all of that evidence in phase one, and the jury returned this verdict.
You had the same exact proof in phase one that you had in phase two? You had
No,
the same witnesses, the same amount of evidence?
No, sir, we did not. We were not permitted to adduce in phase two all of the evidence that we would have produced if we could have. And that's a part, of course, the appeal that we think that the court doesn't have to reach in this particular case. But I'd like you to look at Mr. David's post-trial motions in phase one. There were three of them. He made a motion for new trial, a motion for JNOV, and then a motion to rehear his motion for JNOV. And in all three of them, Your Honor, he argued there was no evidence to establish that Mr. Massey's damages were greater by having the settlement imposed upon him than if he had taken the case to trial. That was what he argued. He didn't argue that there was no evidence of malpractice, but there was no evidence of legal causation of damages in the very sense that we're talking about, that had the case gone to trial, he would have received a better recovery. The judge denied them all, and he did it correctly because there was plenty of evidence to establish that, as of course we argued to him. Now, David is stopped to take a different position now on that matter. That is settled, and all we have to do is quantify damages. And we respectfully submit, Your Honors, that you ought to return this case for a phase two trial on damages only. And when you do that, Your Honor, we respectfully submit that this court should require the claim or permit the claim of punitive damages to be tried. As you know from the brief, we made 6 different motions for punitive damages, all supported by evidence in the record of Mr. David's wrongdoing. All of them properly presented to the court, and they were all denied. The last one included, of course, the jury's finding that
If we send it back for a retrial on phase 2, how would that differ from the phase 2 trial you already had?
We were not you mean a new phase 2 on damages, or are we going back to the other point, Your Honor, as opposed to punitive damages?
Yes.
Okay. We would, in fact, present evidence only as to the damages that Mr. David suffered, and David would present his rebuttal evidence on that point.
In other words, you want to go back and present only the physical condition that he's found to be in and the injuries he has, regardless of whether or not Kugler and Cabot had any responsibility for that.
Your Honor, our position is that it's been determined that Kugler and Cabot and Coppers had responsibility. But with that caveat, yes. And in fact, before the judge below, we argued. He asked me, are you saying that there's a directed verdict in phase 2 on liability? And our answer is yes, because it's been determined. Liability has been determined. And we also made a motion for directed verdict at the end of the plaintiff's case in phase 2.
You're saying that the liability determination in the first phase was more than just that he was denied his right to go to trial.
Absolutely, Your Honor. That matter was not argued to the jury in final argument. What was argued to the jury and what was required by this verdict form was that he suffer legal damages, in the sense that we mean damages. The Supreme Court has told us it means a legal obligation remaining to be quantified in dollar terms. That's what legal damages is. So when the trial court said, oh, well, I think that the jury determined negligence, that's what he said at one point. Well, that's not the way he instructed the jury. It's not the verdict form, and it's not the way the case was tried, most importantly. Not the way the case was tried.
I believe Judge Chance was involved with this case at one point.
First judge, Your Honor.
Did he preside at the phase 1?
He presided at phase 1.
And so then you had a successor trial judge by the time you got to phase 2.
Correct, Your Honor. We had 2 judges. Your Honors, the second major point here is that in any event, this verdict must be reversed and returned for trial because of the blatant and clear violations of the Dosdorian rule in this particular case. The jury was deceived as to who the parties were. The jury was never told that this was a legal malpractice action. They were told that it was a direct action against Coppers and Cabot, which it was not.
Didn't that work in your favor?
No, sir. It did not. But it doesn't matter, Your Honor, whether you should think it does or not, because the Supreme Court in the Peralta case has said this is per se error in which there is no harmless error analysis permitted. It must go back to be tried over. And for these reasons, Your Honor, we recommend, or we suggest that this court must reverse for a new phase 2 trial on damages and punitive damages.
Now, you originally agreed to this procedure, right?
No, sir.
Never.
Your Honor, we never agreed to the procedure. At some point, we had to fight as to how to couch it to the best advantage of our plaintiff, but we never agreed to it in the sense that I think you're saying. This was initially David's idea. The judge accepted it, and we knew that we were going to do it that way. And therefore, we attempted to, if we're going to do it, let's do it in the way that's least damaging to our client. But we did not agree to this procedure.
All right, now we're back to this question about damaging to your client. And how was it damaging to your client?
My client has very severe mental damages, Your Honor, and damages to his brain. He suffers,
I mean, how is this procedure, the trial within the trial, in which the jury was, as you...
well, among other things, it deprived him of the right of trial by jury. He did not have a trial against the defendant, which was David. He had a mock trial, a charade trial against somebody else. That's how it was damaged. And of course, there were other errors which we adhered to, our brief, to support the need for correction if that should be required. But our client was damaged because his constitutional rights were violated, among other things. Thank you, Your Honor. You want me to leave this up here, John?
May it please the Court, John Duvall on behalf of the appellee, Calvin David. Your Honors, following a 2002 reversal on summary judgment by this Court, this legal malpractice case went back for trial in Alachua County. With the consent of both parties, the Court bifurcated the case. Judge Chance ordered...
Before you get into to responding, if you would please, you're reminding us about the history of the case. Now, you are arguing here law of the case?
I am, Your Honor.
And could you just outline that for us?
Sure. We believe that the underlying case is part of this case because of the unique feature of the legal malpractice case. Both parties and the Court looked to the decisions in the underlying case when we set about trying Phase 2. Among the decisions reached in the underlying case, we contend was the decision made by this Court in affirming on 2 occasions Judge Chance, Judge Blunt, and Judge Reinman's orders that said the retainer agreement, which is the subject of legal malpractice, was valid and appropriate. And therefore, we believe summary judgment should have been granted on that basis in the case not gone to trial. That's the essence of our law of the case argument, Your Honor. The Phase 1 trial set by Judge Chance was the attorney malpractice case. That is, whether David was negligent and breached his fiduciary duty by entering into this agreement, which I just mentioned, which said, in effect, that if there was a substantial disagreement between the attorney and the party over various things, discovery disputes, all manner of important issues, including settlement, that issue would be given to a third party who would hear the parties out and render a decision. That process was followed, and the settlement came about.
Well, it wasn't just negligence or breach of fiduciary duty, was it? Didn't they also have to find damages?
No, they did not have to find damages, Your Honor. They had to find that...
Didn't they have to find that legal damages had been caused?
That Massey had suffered damages as a result of the negligence and breach of fiduciary duty. That's precisely correct, Your Honor, and it's Judge Chance who...
So don't we have 2 inconsistent verdicts here?
No, not at all, Your Honor. And that's, I submit, the whole fallacy of Appellant's argument. Legal malpractice cases are a unique animal. There are 2 findings of causation that have to be made in order to sustain a legal malpractice verdict. First, you have to determine that there was a legal malpractice by the attorney which caused damage to the client. That is the first issue of causation. And here, as Judge Chance, who tried the first case, said, the damage was Mr. Massey didn't get his trial. This agreement, which was entered into and which the jury found was negligent on behalf of the attorney, prevented him from having a trial. Instead, he got a settlement. Then, and this is unique to legal malpractice cases, you have the case within the case, the underlying case.
But Mr. Duvall, now I asked Mr. Little that question. He says in the very first trial, he proved more than that he didn't get his trial. He proved that he was injured by Coopers and Cabot Carbon.
I heard him
Now,
say
straighten me out on this, as you understand it.
Your Honor,
Because the verdict was that there was negligence that resulted in damage.
that's correct. And that Massey was damaged by his inability to go to trial in the underlying case. He did not prove causation on behalf of Coopers and Cabot. That's the question that Your Honor asked, and that was not proved. Indeed, at the beginning of during the pretrial of Phase 1, Mr. Little listed a number of witnesses, fact and expert witnesses, and we objected. We said, this is Phase 2. And he withdrew those witnesses, and the ones he didn't withdraw, Judge Chance struck, because that was not part of Phase 1. There was no medical testimony as to causation with respect to that. The testimony that he cites in his brief was as to the mental condition of Mr. Massey, which was put on for one purpose. Part of the contention in Phase 1 was that he did not understand the agreement, that because of mental capacities he couldn't understand that agreement. The judge permitted him to put on limited testimony with respect to his mental capacity to understand the agreement. But there was not evidence with respect to whether or not Coopers and Cabot had a causation case that was tried in the underlying case. That, following the jury verdict in Phase 1, the case went to trial in Phase 2. Judge Chance stepped down for retirement, and before he stepped down, Mr. Little made his motion, which he presents to this court, saying, Judge, all we have to do is come in and show how much we would have gotten. Judge Chance specifically overruled that and said no. What you proved in Phase 1 was the underlying legal malpractice and the damage in not obtaining a trial. You now have to go to Phase 2 and try the underlying case. And that's precisely...
How are you damaged by not having a trial if at trial you would have recovered less than what you settled for?
You're not. And that's precisely what Judge Chance said. So, Mr. Little, not only do you have to prove causation, but you have to prove that that causation resulted in more than $900,000 worth of damages. And he wasn't able to prove that because the Phase 2 jury, hearing the evidence in the underlying case, said there's no causation and no damages. Therefore, Coppers and Cabot were not the legal cause of the injury in the underlying case. That's precisely what this court held in the Olmstead case.
Therefore, any negligence or breach of fiduciary duty did not result in legal damage.
No, it did. It did, Your Honor. It prevented him from having the opportunity to try a case. That was the damage he suffered. The Phase 1 jury found that Cal David prevented Mr. Massey from the opportunity to go to trial and seek recovery in the underlying case.
But that had no value in terms of dollars.
It had no value unless he won the underlying case. And that's precisely what happened in Olmstead. You'll recall the attorney there failed to preserve in the pretrial statement the 1981 claim, which was worth $3 million, according to the jury. The case came back then on a legal malpractice, and this court said, yes, but the 11th Circuit would not have upheld a 1981 case because this was a white man, he's not in a protected class, and he had no recoverable claim. Therefore, the fact that the lawyer committed malpractice prevented him from going to trial to get the recovery, suffered no injury, and he doesn't get the $3 million. Same thing happened in Suresnap versus Vann out of the 3rd DCA. The attorney there failed to present a legal malpractice, a lender liability case in bankruptcy court.
So you're telling us that basically what was established, the only thing established with respect to damages was that the man should have been entitled to reject the, what was it, $750,000, $900,000 settlement,
Right.
and go to trial and take a chance of getting nothing.
That is the whole essence of the complaint. If you go back and look at the underlying complaint, the whole essence is The lawyer was wrong in forcing him to take this settlement under the agreement. The lawyer was wrong in enforcing that settlement, and the trial court was wrong in enforcing the settlement and requiring Mr. Massey to take $900,000. That's the whole essence of what was said. There was no contention in Phase 1, nor could there be, as Your Honor asked. Why have a bifurcation if you're going to try causation in Phase 1? The fact was, legal malpractice cases have two types of causation. The causation with respect to the attorney's negligence, that we concede was proven. The causation with respect to the underlying case, here that was not proven. The jury, after 2 weeks of trial, said Cabot and Coppers did not cause the injuries about which you are here complaining and rendered a defense verdict.
Could you tell us a little more about the witnesses who were struck that had been listed for Phase 1?
There were witnesses that talked about the emissions from the site, the smells that they had, the injury to their eyes and their clothes, the expert witnesses with respect to medical causation. None of that was permitted to go in Phase 1. The only limited medical testimony that was presented was the testimony with respect to whether Mr. Massey could understand the agreement, whether his faculties were so impaired that he could understand the agreement. The causation with respect to the recurrence of his multiple sclerosis, which is the underlying claim that he made, was not permitted to be made because that was the causation in the underlying case. With respect to the other issues that Mr. Little addressed, Your Honor, there were no punitive damages in Phase 1 permitted, although that was presented to the trial judge in the underlying case. The actions of Mr. David certainly did not serve as a basis for punitive damages. What he was doing was seeking to enforce an agreement that he and his client had entered into. He had gone to the trial judge, Judge Reinman, before the agreement was even executed to get prior approval by the trial court, just as attorneys do when they have an instance that they seek to get a greater recovery than the bar permits under the rules. Judge Reinman permitted the agreement, he okayed it, it was then entered into, and ultimately Mr. David sought to enforce it. Jury in Phase 1 found he was negligent in doing so, but it certainly doesn't rise to a standard of punitive damages. The final point Mr. Little mentioned was the Dostorian. Dostorian, of course, held that Mary Carter agreements were impermissible. The reason they are impermissible is because the defense lawyer enters into a settlement agreement and then continues in the trial, making it look like he's defending the action, but in fact, he's gone over to the other side, to the plaintiff. Justice Rhimes said in that opinion that that is inappropriate, should not be permitted. We did not have that here, Your Honor. What we had here, and what was first advocated, in fact, by Mr. Little at the pretrial conference, was that Mr. David's name was not to be announced in Phase 2. Obviously, in Phase 1, he was a party and his responsibility was there for the jury to see. But in Phase 2, it was suggested by Mr. Little initially, and the judge agreed, that it would be confusing to the jury, that it would only serve to prejudice the jury, that the jury should look only at the underlying case, that is the responsibility of Cabot and Coppers in making that decision, and not be distracted by the fact that there was a legal malpractice case out there. Similar to the case where you have an attorney representing an individual charged in tort, but in fact the attorney is employed by a liability insurance company. The fact that he's representing the insurance company has no basis in the trial. It simply would have the effect of prejudicing the jury. On a similar basis, Judge Roundtree said it seemed better to him, after studying the matter, to make no mention and to try the pure case between by Massey against Cabot and Coppers. That's the case we tried for 2 weeks, and the jury returned a verdict in favor of those entities. And most importantly enough, contrary to the statement in appellant's brief, at the pretrial it was stipulated and agreed that if the verdict went against Cabot and Coppers, David would be held responsible and the judgment would be entered against him in the case. That stipulation is cited in our appellee's brief. Unless the court has further questions, I will give up the balance of my time.
Right. Your Honor, I'd like to go, Judge Barfield, go to your question. What evidence we present? We presented the evidence of neurological expert MD Dr. Walter A. Field, and this question I asked him, this is phase one. Then in 1994, did you reach a medical opinion within a reasonable degree of medical certainty as to whether or not Gary Massey's multiple sclerosis-like symptoms were caused by exposure to toxic torts at the place where he worked? Yes, and this is the answer. Yes, I think they were. That's what caused it. Mr. David has just told you there was no evidence. There was evidence, and I'm giving you the key evidence here. Dr. Singer was asked this question, and prior to 1996, did you form an opinion to a reasonable degree of scientific certainty whether exposure to volatile compounds repeatedly emitted from the copper cyclical operation and the Cabot site 82 to 87 time period was a cause of the neurological injuries and neuropsychological injuries that Gary Massey suffered? Yes, I did. And what was your opinion? That it was a cause. And are these opinions based on ample data and established scientific principles and analysis? The answer was yes. These questions and answers were not objected to. And that was the evidence that was before that phase one jury, Your Honor, to make the determination that was made in this particular case. Now, Mr. Davis.
Now, let me make sure I understand this. You're telling me in the phase one trial on the legal malpractice claims that you tried the question of the liability of Coppers and Cabot for the injury to your client.
We did.
Then there never should have been a second trial?
Your Honor, whether there should be a second question of trial is not before us.
It was mine. I thought
it was tried.
Mr. Little, as I looked at this case, it appeared to me that your client contended he didn't have an opportunity for a trial that he should have had, and the first jury found that was true, and he got the trial that he thought he should have had.
Your Honor, there's nothing in that verdict form. There was nothing to the instructions to the jury that said anything about damages, being that he didn't get the trial that he thought he should. What was argued to the jury was that if he had gone to the trial, he would have gotten a better recovery than he got in the settlements. And that's damages, Your Honor. So please don't take what was said here as to what the appellee wants you to think was presented.
And this record should reflect then that you left that first trial with understanding the only thing that you would have to prove in the second trial was the extent of injuries and the value of those injuries to your client.
It will show that. It will show that. We immediately moved for that, Your Honor, because we knew what we'd proved. David did too. Take a look at our brief and what his motions were after the phase one trial. He repeatedly said, you did not prove that had you gone to trial, you would have recovered more than the settlements. 3 different times in post-trial motions. We, of course, showed the judge the evidence that we did prove that, and the judge agreed with us, Your Honor. So that's been proved. He should be stopped from taking the position that he's taking now. Your Honors, the Desdorian matter speaks for itself. This court cannot permit that phase 2 trial to stand. It's a plain violation. Whether or not I had anything to do with it or not is irrelevant, Your Honor. It's a plain, per se, no harmless error analysis. For the reasons argued, Your Honors, Mr. Massey respectfully requests that the court reverse, set the phase 2 trial on damages and punitive damages. Thank you.
Thank you, counsel. We'll take a recess for about 15 minutes.